said before, this is the last meeting of this subcommittee before crossover, unless we get referred a new bill either from criminal or from another committee that re-refers something over here. Our docket is heavy, although we're going to take some administrative actions that's going to clean it up a little bit. We're going to give everybody a full opportunity to be heard, but again, this is the last meeting, so if you've got work that needs to be done on your bill, you need to be out in the hall getting the work done before you come in to present your bill today. We are not taking any bills by for the day, and every bill that has been taken by for the day is on today's docket. All right, so administratively, we have 4 bills that the patrons have asked us to strike. They are House Bill 1557 from Delegate Krizik, House Bill 1643 from Delegate Lumpasi, House Bill 1739 from Delegate Minshew, and House Bill 1989 from Delegate Weber. Have a motion to strike those bills? All right, move second. We strike those bills. All those in favor say aye. Aye. Those opposed? All right, those bills are stricken. We are going to get started. I am not super comfortable with the fact that even though we have a quorum, it is only Republican members sitting up here. So if anybody really cares, if the Democratic members need to be in here, they're going to testify. If anybody in the audience is wondering if any trick was pulled, this is not an attempt to stack the docket in a partisan way. This is just who's in the room. There are a bunch of our members that are going to be coming back and forth, hearing bills over, presenting bills over the other room. Several people are on the driver's license suspension docket that CrimSub's going to do. That's going to be their second big block of bills. So we'll have people coming and going. It is not our goal to affect the outcome of any bill based on who is or isn't in the room. So if we move some bills around to have the right people in the room, it's only going to be fair for the folks presenting their bills. We will hear the folks who are here for the first time and are in the room. We'll hear their bills first. We're then going to hear the bills of folks who've been taken by, and then we'll finish the bills of folks here in the room. It is not the policy of this subcommittee to allow bills to be presented by lobbyists without the member here, but because of the weird scheduling today, this being our last meeting, that theoretically could arise at some point, and we'll do that if we need to. I can't see if anybody's behind the podium, but Delegate McQuinn, I think you have a couple of bills with us today, and we have not heard your bills yet. So why don't you come on up? Is your first bill 2229? 2292. This is the judicial training requiring the Office of Executive Secretary to train on people with legitimate interest.
Yes, sir. Thank you, Mr. Chairman.
2292.
Okay, 2292. Okay. 2292 is again the judicial training law related to the rights of personal legitimate interest in custody, and it is just asking that the Office of Executive Secretary, Supreme Court of Virginia, requiring that all juvenile and domestic relations district court judges receive training at least once during each 6-year judicial term on the right of persons of legitimate interest in child custody and visitation proceeding. And what this is all about, it was brought to my attention, and I didn't realize how prevalent it was until this paper, this bill was presented. But each of us know, if we've had any relationships at all with our grandparents, how grandparents play a very affectionate and loving and matter of fact resourceful and integral part of our family. In my experience over the 25 years, their value has been strong and remarkable, and they bring something to the table that a lot of times children don't have. And so we're living in times that it appears that grandparents are taking a greater role and responsibility in helping to become custodian for grandchildren. They become advocates and ambassadors, and they are actually a positive factor in that child's life. And so what we have found out of that, and in doing this, many because become grandparents, become so involved because of the opiate epidemic, other crisis, death, and just many things that may happen that seem to be a part of an unfortunate situation in many circumstances. And so after the grandparents often children, like some up to 5, 6, and 7 years. And then when the parents come back into their lives and it becomes a court issue, we're finding that sometimes grandparents who have raised their child or who have been very involved then become, pushed aside. And so this bill really is looking at, as they go to courts, before the courts, that the courts will give strong consideration to the fact that that grandparent may have been very, very involved in that child's life. And we're finding that sometimes decisions that are made are just not favorable. And personally, it doesn't seem to be favorable to the child or to the grandparent. And so we're just asking that training would be given to the judges, particularly those in the children in domestic courts, that juvenile domestic courts, that it would be given to them to address this issue. The Senate bill, there is also a Senate bill identical 1190, and it's introduced by Glenn Sturtevant, Senator Sturtevant. So we are both asking, he'll be carrying the bill on the other side, and I'm carrying it here. And we're supposed to have some grandparents who are actually here today whose lives have been affected by that situation.
Is there anybody here to speak in favor of the bill?
Are they here?
They're coming right now.
Where are they?
They're where the elevator stops.
Would you like us to suspend on this bill and go to your other bill so
Yeah.
that those folks can get here?
Yes, sir. That'd be fine. Thank you.
Hold on a second. Go ahead, Toscano.
Can I ask a quick question? Is this identical to Senator Sturtevant's?
Yes, identical. Yes.
And it's a Section 1 bill.
Right.
Directing the Office of Secretary. I think we'll probably have a lot of questions on this bill and for the Office of Executive Secretary, but we want your folks who have come over to testify to get the opportunity to do so.
Okay.
So if it won't do harm to your presentation, let's suspend on 2292 and pick up on 2293. Are they here to testify to this, or this same group testify to this as
Yes,
well?
they will. They will.
All right, then let's do this. Let's have you sit down for just a second.
Okay.
Let's hear Delegate Wilkes' bill. This is a bill we heard before and carried over for them to work out some language.
Okay.
So it shouldn't
That'd
take
be
too
fine.
long, and then we'll pick yours up
Okay.
when your folks get in.
Thank you.
Thanks. This is Delegate Wilkes' bill on the death certificates that somebody on this committee raised some concerns with. They've worked very hard to address those concerns, and I think have done so. Is the last version the one that's before us, or is there a line amendment to the last version we have?
There's not the substitute that's in front of you is the finalized version.
All right, so take a look at the stack of substitutes you have at 2276. It's about just past the midpoint of your substitute stack there. This is about amending death certificates. And there were some issues about who can amend it, what jurisdiction they file in, and who gets notice. All three of those issues have been addressed. They're giving notice to spouses and immediate families. They're filing in the jurisdiction where the decedent resided at the time of death, and they're giving notice to the parent, spouse, other things. So everybody had a chance to look at the substitute? All right, have a motion on the substitute. Move to adopt substitute to House Bill 2276. Move to second. Any debate? Hearing none. Those in favor say aye. Aye. Those opposed? All right, the substitute's now before us.
Yeah, Mr. Chairman, we've already discussed the issue at hand. We've made the changes to try to address the concerns of the committee. I just open to any questions or.
I think only one obnoxious member of the subcommittee had concerns. I think they've been largely addressed to that member's satisfaction. Anybody else have any concerns?
Move report. Second.
All right, we have a motion to report the substitute House Bill 2276. Moved and seconded. Any debate? Hearing none. Those in favor say aye. Aye. Those opposed? All right, thanks for your good work on this. Thank you. All right, I don't think we've got the grandparents in unless the dude who looks too young to be grandparent back here. Redheads hang slow. All right, we here? Here. All right. Come on up, Delegate. You are making a dramatic entrance because we were. You don't even know who you are. Good job. Well, Belton Quinn's gonna come back on. She'll resume the podium. We're on 2292. This is the Section 1 bill, direct the Office of Executive Secretary to provide training for our personal legitimate interest. Did you have a chance to present everything you want to present, and now it'll be time to hear from folks?
On this particular one, so
Yes,
he's
ma'am.
one of the gentlemen that come right on up.
Great. Would you like a minute to case Brad? All of us are so out of shape that we're used to. Introduce yourself and offer your testimony.
Yes, sir. I'm Wally Dorsey, grandfather of Jacob Alexander, live out in Powhatan, Virginia.
Go
been in the military for 12 years, has 30 days leave every year. Never spent 1 week with his grandson or with his son. He would spend the weekend when available, if it was convenient, with his son. When our daughter passed, he went for custody and he got custody. Parental preference just trumped everything. He told his son he would never see his grandparents again. It got really ugly. We now have visitation with our grandson, but his sister is still at the house with us. So his father just pulled the brother away from the sister, pulled the son away from everything he's ever known, the Cub Scouts, within the school, all the school functions. So he's taken this boy from the only home he's ever known and forced him to live with somebody he's never lived with. Visitation is a good place to start for many people. I was floored at 3 of the delegates that I've talked to have had similar experiences where the child's best interest was where they were. And that needs to stand much taller in the minds of the courts. So the training that Delegate Quinn is offered speaks to that, so that the judges understand the impact of what it is that they're doing when they take a child from a home that they've lived in for virtually their whole life.
And did you all, in your case, apply to the court for visitation rights?
We arranged all that before we got to the court. Okay.
You apply for custody and
This is my wife.
And so were you able to get visitation rights from the court?
Yes.
Okay.
only because he agreed.
Hold on a second. Come on, we will time you.
Only because he agreed, and he only agreed the night before our court hearing.
I just want to make sure that we didn't have a situation where the court, without a legitimate purpose, had prevented you all from getting visitation. So, okay. Sorry about the loss of your daughter, and thank you for being so involved in your grandchildren's lives. Did you want to offer something in as well?
Yeah, I can just reiterate what he said, Jacob, begged, to stay with us, he agreed with us. And he wanted to stay with us, and he told his dad he didn't want to leave. But I mean,
We're looking at it from a different perspective. We're not looking at it from grandparents' rights. We're looking at it from the children's rights. These children have a right to stay with each other. This is the siblings that they've been together from the day they've been born, or from the day Abel was born. So we're looking at it from a different angle. I know that it still comes up with grandparents' rights, but these two kids deserve to be together.
Okay, do we have others here to testify to the bill?
yes, this kid.
Come on up and introduce yourself and offer your testimony.
Hi, I'm Lola Kidd, and I visited Delegate McQuinn to tell her about my story with regard to being a grandmother. I'm a grandmother to a 7-year-old. In the first couple of years, or 6 years, were very tumultuous because my son and the mother didn't have a good relationship, so we were in and out of court. And on one visit to court, the judge actually told me there were no grandparent rights. So while there's no law for grandparent rights, there is a law that would allow me as an interested person to have some right to her. Subsequent to all of that, my son passed away in August. And the good news is my granddaughter's mother is now much more amenable and understanding in terms of the role of the grandparent. She sees the value that we have, the bond that we have, the relationship that we have, and the family unit that it creates. And in her case, it also offers some continuity in having lost her father and still having some relationship with this family. Had the mother not been amenable and open and changed, had she not changed, then I would be fighting today, grieving over my son, and yet grieving over my granddaughter. So I too offered the training for the courts, since I was told personally that there are no rights for me, and also that we make it easier for not only grandparents, but all interested parties that are blood relatives of these children to be able to visit with them. And again, I echo what was said a moment ago. It is about children's rights. My granddaughter is called Angel, so it's her right to see me and have a relationship with me as well as I am with her.
Thank you. Thank you for being involved in their lives.
with this child. I have provided physical as well as monetary support to these people. I've spoken with many other women who have experienced the same thing, where they're providing child care, where they're providing money to a grandchild, where they're being the babysitters, but then they're being emotionally blackmailed by their own children or the spouse of the children. For the children who are in need of special care, as mine is, the parents themselves also who need more time and more attention in managing their own lives. We, the grandparents, or the people with legitimate interest as the well-being of a child here, have the right to visitation with these child. We cannot rely on the schools, the daycare, the state of Virginia to provide these needed emotional supports. If grandparents have the right to visitation with their grandchildren, we can then take some of the responsibility away from the social workers, the courts, or the state of Virginia. If we are able to make sure that proper care and housing are being provided for these grandchildren, it will only help to strengthen the American family unit and the building blocks of our social lives. We need grandparent rights. We need grandparent visitation. It is our right to take care of our own families and these children.
Thank you so much.
Thank you.
Anybody else here speak in favor of the bill? Anybody here speak in opposition to the bill?
Good afternoon. My name is Larry Deal. I'm with the law firm of Barnes & Deal in Richmond. I practiced family law for over 42 years, written a treatise on family law, drafted many things, appeared before you in the past. I'm here on behalf of the Virginia Bar Coalition in opposition. Let me just say I agree with everything everyone has said. There's no question that grandparents have a great role. I've represented both sides of these practically. But the law is clear and the judges understand that. The law that we have to deal with is a U.S. Supreme Court case called Troxell versus Williams, which was adopted by a case called Griffin versus Griffin in Virginia. And the standard is that you have to prove substantial harm to the child if you don't have a relationship, whether it's custodial or visitation with grandparents. That's a very tough standard to meet. But the issue of this particular bill and 2293, which is coming up, is probably unconstitutional too. But the issue is not educating these judges. It is trying to get the proper proof to get that nexus between the ability to show that there would be harm to a child. Griffin says it's not just the general loss of the grandparents, because I've had judges say, look, grandparents are apple pie. Everything everyone has testified to is absolutely true, and it tears your heart out. But the U.S. Supreme Court says, but it's the parents' Fifth Amendment constitutional right to raise children without the interference of the state. Do they have standing to come in and ask for it? Yes, we already have statutes on that. There are appellate cases that have approved grandparent custody or visitation on appeal on facts. And so these are factual-driven cases, really. And so our position is that education is not really the issue because the law is the law. And most judges, I don't think there's anybody that I've practiced in front of that's not aware of these case laws, which really controls. It's a matter of, and judges know this. I mean, I've had judges really say, I wish I could do it. It's apple pie. You would be good for these kids. But that's not the issue. The issue is the Troxell case, which trumps everything until the U.S. Supreme Court changes it. The other issue that in opposition is if we're going to educate judges on this, we've probably got a lot of issues in family law that we'd say, why don't we education this, and this. This is probably more something that maybe the General Assembly could direct the Educational Department of the Supreme Court to say, could you focus on it internally rather than statute? So I want Adela McQueen to understand, we all want the same thing, but we do have to be bound by the standards that are Supreme Court, Virginia, and that's the law. And so that's why we're opposing it, not because we don't want grandparents. I represent many of them.
Right. Okay. Doug Toscano.
Can I simply point out that this is a Section 1 bill, it's not in the code, and all it does is require the Supreme Court to conduct training on the rights. It doesn't say that a judge has to decide anything.
Right.
The judge would always consider the law. So I hear what Mr. Deal is saying, but this is not written in the code. All this is an instruction to the Supreme Court.
I think Mr. Deal's substantive objections are probably better laid to the next bill or to another bill that's not before us. I think frankly the question before this court is, for this committee is, do we want to start down the path of directing certain items of the law that we want judges to learn, and by not directing another item, are we excluding that from the list of things we think is important, that type of thing? Let's hear
Chair, can I ask a question of the chair?
Yes.
Or maybe it's from the delegate McQuinn. Delegate McQuinn. Did the Office of the Executive Secretary ask you to put this in?
No, they did not.
Right here.
Even though I did, no, they did not.
Okay, thank you.
All right, come on up.
Thank you, Mr. Chairman, members of the committee. Sandra Carrison, Office of the Executive Secretary, Supreme Court of Virginia. I appreciate the opportunity to talk about judicial education, and I'd like to echo Mr. Deal's comments to the effect that judges do know what the law is, I believe, in this area, and it is, the strong parental presumption according to the case law. As far as judicial education, and also echo the parents because I'm a grandmother, so on a personal level, I understand that bond and that involvement. As far as judicial education, the process is very rigorous. We do have a lot to educate judges on. We have committees of the judicial conferences that meet to determine, the judges give evaluations, they give feedback, they let the committees know what they need education on. We're very sensitive to what is new and happening, and a lot of work goes into the department that Dr. Caroline Kirkpatrick operates in, the Office of the Executive Secretary. In point of fact, on this particular issue, it is covered in pre-bench materials so that when a new judge comes on the bench, they do receive information on the subject of third-party custody and visitation. And that material quotes the Proxel case, as Mr. Deal
I was going to ask you, could you give us a better understanding of what is included in the pre-bench materials that's provided to every judge before they go on the bench?
An article that was recommended by Judge, I believe by Judge Debbie Bryan, who's been on the bench for 14 years. She teaches a pre-bench, and then we have another judge, Judge Chipwood, also teaches that area of pre-bench. He's been on the bench for longer than that, so we have about 30 years of judicial leadership there teaching at pre-bench. And if we teach the JDR judges, we need to teach the circuit court judges too, because, and we do, by the way, because when there's an outcome that someone is disappointed in, our system has the right to appeal. And so that's kind of how that goes. We have so many issues to educate on, and partly that comes of the work that you do. So thank you for the opportunity to speak. I'd be glad to answer any questions.
If we pass a substantive change to the law, like 2293 that's coming up next, or another bill, or if an appellate court comes out with a new decision on point, or a significant trial court comes out with a decision, how do you communicate those changes to your sitting judges, not your pre-bench materials, but to your sitting judges?
Our sitting judges receive every judicial conference, which the mandatory conference, we've had to eliminate some conferences years ago because of budget cuts, which is another issue, the resources that have to get spread thin. But we have case law updates. We have, if it was a Virginia case, we have a session on updates from the appellate courts every year. And in the area of family law and other law, of course, criminal law, we also have U.S. Supreme Court updates. And so that would be, this particular area, of course, is directed by U.S. Supreme Court case law, but in any event, we also change, we do judicial education on legislative changes every year. The circuit court judges will have a mandatory conference in May of this year, and then the district court judges follow in the end of August this year. They'll get a legislative update and a case law update.
And that happens every year?
Yes.
All right. Doug Toscano.
Do you think it would be possible maybe to share the piece of paper from the training with Delegate McQuinn so she can share it with the folks who have very legitimate concerns? It's interesting because I do a lot of work in this area. There's not a month that doesn't go by and I don't get a call like this.
You have
Lots of
Are there other places in section 1 or elsewhere where we have directed the content of the training you provide for judges?
If so, I am certainly unaware of it, and I believe that I would be aware of it, having been in this office for 17 years.
Okay. All right, is there anybody else here to speak in opposition to the bill? Anybody who has something to offer but is ambivalent on the bill? Okay. Any more questions for the Office of Executive Secretary? All right, Delman Quinn, you get the last word.
Mr. Chair, I just want to, and these grandparents have come up, and I don't know if we realize, and I hope we do, or we may not, that this is a very prevalent issue. We are in these times just sort of forces grandparents to step in to help take care of the situation. So either we can sort of get on the front end of it, or we'll be lagging behind as Virginians to help find a way to bring resolution to this issue. 2.7 million grandparents are responsible for the basic need of their grandchildren, and 36% of the grandparents have provided care for children for over 5 years. And so I know there are case laws, I know all of that, but the bottom line is that we have a situation that we need to bring some resolution to on the benefit, not just for the benefit, not just because grandparents are emotionally attached, but children who have been abandoned, and just kind of tossing them around like they're a pawn is not acceptable. So I just wanted to say that, and then the other bill sort of speaks to that, something similar, just say that.
Let's deal with this one and then we'll get to that. You know, you've identified a real issue, and your folks here have identified a real issue, and it's a place where the Constitution is running headlong into the practical realities on the ground, where both the U.S. Supreme Court and the Virginia Supreme Court have sort of enunciated very clearly the primacy of parental rights. But the world we live in today, so often the best interest of the child on most objective measures isn't with that person, but that person is the one with the constitutional right. And trying to balance that is something this committee actually sees every year with various bills, like your 2293 we're about to hear, and others. The concern that I have with this one actually is nothing to do with substance, but totally process, which is that I'm hesitant for this committee to get in the business of directing the content of the training that the Supreme Court does. As I think as the Uber chairman has some Latin phrase about when you legislate one thing and don't legislate another, that you're intentionally excluding. And if anybody remembers that phrase, they're better than I am, from law school. But once we go down this path, I feel like we may have to go all the way down this path and actually say, here, we're going to legislate this book be the training manual, or else we run the risk of excluding something by not including something. So that's my concern. It's totally a process issue, understanding very much the concerns of these folks and the way the system isn't meeting their needs and maybe not meeting the best interests of the children either.
And Mr. Chair, and I understand that, I understand it totally, but I guess I can't think of anything more important than us trying to take care of the child, because the bottom line is, if many of them continue to live in situations and circumstances that some of them find themselves in, and that's not very positive, then they become our problem anyway, either through the judicial system, prison, or some other way. And so,
what if we did this, Donald Quinn? What if rather than sending your bill forward, we forced Mr. Deal and the Family Law Coalition and the Office of Executive Secretary and you and me and Toscano or whoever else to sit down and look at the training materials that are currently being used?
okay.
And maybe we'd be satisfied, maybe we wouldn't be satisfied, and the threat of your bill hanging out there would encourage them to make us satisfied. Would that be maybe a way to do it without having to legislate today, you think?
It helps move the needle down the road, so I'm okay.
You can go with that? Okay. And Kevin Toscano is sort of our family law expert up here. All right, well, so I think then the right motion, if we want to do that, would be to lay this bill on the table here, which of course keeps the bill sitting here and keeps it alive, gives us the opportunity to work with these folks. All right, so we have that motion. Is there a second?
Second.
All right, so that's moved and seconded. That's non-debatable, but just by way of explanation, that does give us the right to continue to try to address these folks' needs. So, all those in favor say aye. Aye. Those opposed? Okay, thanks for putting this bill in. You also have 2293, which also relates to persons with legitimate interest.
Yes.
I'm assuming the folks you have today would lend their endorsement to this bill as well. If they have anything additional they would like to offer by way of testimony that they didn't offer before that relates to this, we'd be happy to hear from them. or we'll be happy to understand that everything they said before is the background of this bill as well.
I think everything that they said before is a background for these, both
Can I
of these
ask you,
bills.
I'm sorry, Mr. Chairman, I believe we have 2 line amendments.
Yes, we did.
Yes.
Hold on, they've been handed to you.
They are
There's,
here in the back.
yeah, page 1, line 28, strike award, and line 128, insert in the best interest of the child. Is that?
Insert the word. actually.
Insert award, I'm sorry. Insert award and insert best interest of the child.
That's correct.
Okay. All right, Nellie McCloskey moves the amendments, moved and seconded. All those in favor say aye. Aye. All those opposed. All right, so 2293 with these 2 line amendments is now before us. The operative language for everyone on the committee is at lines 28, adds the word visitation. So here we're doing with the amendment, after visitation would be award in the best interest of the child. And so the operative language now is the court may award joint custody or sole custody or award visitation in the best interest of the child. Okay. All right, Nellie McQuinn.
I think that this will, since we'll be addressing it all, this will fit right in with the addressing of 2292. And this is one as well, because it clearly speaks that, once again, looking at the best interest of the child and also the relationship between the child and the grandparent, and in light of the fact that it's so prevalent now that we need to do something about it.
And so, for members committee, if you don't have the bill in front of you, the language preceding the change makes it clear that the court gives due regard to the primacy of the parent-child relationship, but that it may, upon showing clear and convincing evidence, that the best interest of the child will be served by awarding custody or visitation of a legitimate person with a legitimate interest.
Right.
And then the sentence you're modifying is the part that makes it clear they can do joint custody or sole custody.
Right.
So the question would be, does the sentence before that already says they can award it to other persons with legitimate interest, does that fulfill it, or does the next sentence need to make it clear that it's not just custody, but it's also visitation? I don't think it's actually a substantive change, it's just making it clear, I think, that it applies to both. Mr. Deal, everything you said before applies?
I've got a little bit more comments very briefly though.
Okay, and before you speak, does anybody else speak in favor of the bill who has new comments to offer? And if you all would like to speak again to anything, we'd certainly love to hear any additional comments. But we understand that what you said before is relevant to this bill as well. Okay. All right, then Mr. Deal, come on up.
Yes, again, the Troxel case does supersede this law. But a lot of times we try to tinker with burdens of proof and other aspects of all sorts of family law. This is an area, though, that we can't. I think there's an old quote, if that's the law is an ass. And probably that's true. I agree. But we can't change the Constitution. Let me give you real quick 3 fact scenarios of how this applies in the real world. You have 2, sometimes my pattern is young kids, they have a child, they're estranged from their parents, the parents are mad that they got married young, and so they don't want to have any contact. Parents have had a good relationship before that until the children are involved, and the court's going to say, you have a right to say no visitation under Troxel. A second fact situation is, what if you have one parent, they're separated, and this happens, mom wants to have visitation, dad doesn't. So you have 2 different parents with it. There's a case called Yacht versus Map, I think is the pronunciation, where they basically said, then the best interest applies. Troxel doesn't apply, because that's a unified Fifth Amendment. They each have conflicting Fifth Amendment rights. The third one is the unfortunate situation of a death of a parent, and so if it's one parent, and that was actually the fact situation in Troxel, there was a death of a parent, and the Troxels wanted to get visitation, and they set the standard as being a substantial detriment to the child if the parents don't have visitation. Very difficult to do, and they're not talking about general harm, but something very specific. So again, whether we like it or not, whether we want to honor grandparents, this is unconstitutional, we just can't do it. Or it's going to be, if you pass it, I think it's going to then be a question, and somebody's going to be taking it up to the Supreme Court of Appeals or make it the Supreme Court.
Mr. Chairman? Mr. Chairman?
No, I just comment.
So I'm glad that Mr. Deal is here, because he is the expert, and we appreciate your expertise. Are you saying that this whole section of the code ought to be rewritten because it seems to imply something that that really isn't the case? I mean, D1 says the court shall give due regard to the primacy of the parent-child relationship, but may, upon showing clear and convincing evidence, that the best interest of the child would be served by awarding someone visitation or custody to someone with a legitimate interest. in light of what you just said, should we change this language? Because it sounds like it's something different under the Supreme Court.
Yeah, I think that if you literally read, this was adopted before Troxel came out, and so it's more of an archaic, I won't say archaic, certainly it reflects what is a good policy, but now with the Troxel and Griffin state case, it may be saying that it would be best served by the board, but you still can't do it unless there's a standard met of the substantial harm to the child if you don't do it, so.
Yeah, here's the problem that is being pointed out right now. I think the existing law, well, the question is, the existing law might be too friendly to others with legitimate interests relative to Troxel. And then when we start messing with this, we run the risk of getting the underlying statute invalidated in a way that's actually worse for the other people with legitimate interests, which would obviously be unintended consequences.
I don't think the coalition would recommend changing anything right now. The case law is clear, we all deal with it, and we then try to present the facts as best we can for the grandparents in those cases, for the parents. I mean, we represent all sides of this, always looking for the best interest of the child, but the grandparents' rights are paramount as the Troxel case.
So this language has actually been addressed, was upheld in a multi-dissenting opinion, where they said that language shall give due regard to the primacy parent-child relationship, evinces the General Assembly's intent to require the court to find a denial of non-parent visitation is detrimental to child's welfare, for the court may interfere with the constitutional protection of parental rights. In other words, quote, for the constitutional requirement to be satisfied before visitation be ordered over the objection of child's parents, of course, must find actual harm to the child.
That's
so,
the standard.
Yeah, so they sort of
they've read into this.
Yeah, what they've done is in a very sort of gentle reading of our statutes have determined that it does comply technically with the existing constitutional provisions, although there's some mental gymnastics they use to uphold it there that I would hate to cause to be back before them to make them reevaluated, which could be the result if we took this bill forward. I'm wondering if rather than risk that, we should do the same with this as we did with the last bill and include it in our conversations to look at this statute in the existing case law rather than legislating today in a way that could actually hurt the proponents.
Can I say something, Mr.
Yes,
Chair?
come on up.
And Mr. Chair, this is what, you know what, it's good that it's come out because the bottom line is if, you know, when judges are sitting there and, you know, we're talking about training and educating them today, but if they're sitting there, then exactly what case law or what are they reading from and making that determination? So there could certainly be ambiguous in terms of what their ruling should be or what the outcome should be. And so I think based on that, then, you know, we need to sit down and look at it and refine it and making certain that it's saying what it should say and what it should do.
So out of an abundance of caution to not do harm to the others with legitimate interests, I think we should treat this bill the same as the last, which would be a motion laid on the table, allowing us to continue to evaluate these issues and certainly hear from other stakeholders.
Mr. Chairman,
Delegate Scott.
can we ask Mr. Deal if you take this back to the Heaven Heart Coalition and see if we might be able to work through some language and then maybe give it back to
Here's
next year for something?
Yeah, here's what we'll do. We'll
ask. Do that.
Here's what we're going to do. We're going to ask the chairman of full courts to write a letter, and we will figure out if Boyd Graves as a body or the Virginia Family Law Coalition.
The coalition would be the appropriate. I'm on Boyd Graves also,
Yeah.
so is Delegate Viscount. I think this would be
He's the posse, and I'm not.
That's right.
We will ask. We will ask the chairman of full courts, in consultation with the patron of this bill, to send a letter to whoever we determine the appropriate body to be. That is not a formal motion. The motion still lives on the table. We just make a request to the chairman, which he always does, to make sure that we both look at the existing statute to make sure that we are constitutional, not running the risk, as well as any potential updates to statute that need to be. So, okay, with that, I think from my right, I heard a motion to lay the bill on the table earlier, moving seconded. Before I recognize the motion, do you want to say something else?
Yeah, she can say, she just,
Come on up.
Hi, I looked at several laws from many other states across the country. but they seem to me to have done a better job of recognizing the rights of others. So I would ask that in doing the study, that you would also look at how the other states are dealing with this type of situation.
That'd be great.
And factor that into it.
We'll make a note, Britt or Andy, when we asked Delegate Chairman Albo to send his letter to both evaluate the constitutionality of the current law in Virginia, the proposal made by Delegate McQuinn, as well as other states that may have addressed this post-Troxel and any recent cases. So, all right, with that, we had a motion laid on the table, properly moved and seconded. All those in favor say aye. Aye. Those opposed. Thank you, Delegate McQuinn, for bringing these issues to us. Thank you all both for being here, but also what you're doing in your families' lives. I know that's not the easiest thing. I know you all probably love it and love fighting that good fight, but I also know how hard it is to raise a new family as they come along. Thank you. Thank you so much. I, as someone who was raised in a household with a single mom and 2 grandparents in my house, can't tell you how important you are to their lives.
That means you're a good boy.
We took your bill last week, we did send it forward to full, and you're working on some language, I think, on the other one.
Right.
This is your 2385, which we've not heard about court costs.
This is a pretty simple bill right now. Localities can do the e-summons. State police is here and they can come forward too. What this bill would do is extend a very common sense thing to state police. They can also do e-summons, get out some of the paperwork. State police are here to address it, but it's very straightforward.
I think the issue that people are going to have is, does it amount to a giant fee increase? So tell us the mechanics of it, and then that'll, I think, be the one.
Let me just make this point. In paragraph A, it's the same mechanic that you do in the locals. It's replicated in the state police. So you already have mechanics, but you got to do that in order to fund your system and keep it going.
All right, go ahead.
Good afternoon, Mr. Chairman. And as a development advised, this would have provided the state police $5, which was done in 2014 and 2015 for counties, towns, as well as towns. This would solely pay for the equipment associated with the e-summons project, whether it's printers, paper, and things associated with that. That's all the money is for.
Are you all doing e-summons now?
No, we're not.
And how many tickets are written on an annual basis that this $5 would apply to?
Off the top of my head, sir, I do not know that answer. I mean, of course, state police issues thousands of tickets.
Maybe millions of tickets.
It's quite a bit.
Did you all do an analysis of the cost to implement this system and the amount of the fee relative to the number of tickets that are written every year to make sure that we're not creating sort of more revenue or less revenue than's needed?
There was no fiscal impact, and normally if they did that analysis, that's what they do it. I don't have it. Maybe it's on somebody's system.
No, there's no fiscal impact. I think we have to ask the state police how much it's going to cost them to create and implement the system. And then we need them to tell us how many tickets they write on an annualized basis. And if we wanted to tell people we're sort of dollar for dollar just funding this e-system, then we could show them just sort of a math formula. Because my guess is it's probably not exactly the same as this county, cities, and towns one, but I don't know.
Yes, sir, Mr. Chairman. For us, for each vehicle or each car, it would cost about $1,500 to get the equipment in the vehicle for this program.
You're talking about 300 tickets a year would fund the car.
We can certainly get that information for you.
Yeah, so if the bill goes forward, it may be that we would like to have you come to the full committee with that information in hand for us so that we can educate other folks about that.
Yes, sir.
Okay. And is the e-summons relate to what happens on the side of the road or at the crime scene when issuing the summons? That would allow them to issue it, to print it right there from the car. Is that what it's doing?
Yes, sir. Transport directly to the Supreme Court, which is the courts. And in addition, for the courts, now they have to get e-summons from local jurisdiction. With for us, it's paper, so they've got to do 2 different systems at this time, and it's probably going to be easier for them to have one system set up. Correct.
Yeah. So right now, you all handwrite summons, you hand it to somebody, and then you make it a copy, like a carbon copy of that gets sent to the Supreme Court.
Mail to the court, correct.
And I don't know probably others who may share this opinion, which is we would like to consider doing this, but fund it at the actual amount that it takes to implement it, not just pick the number that they had for the cities, counties, and towns, and actually make sure that we're lining the math up right, which would be what we asked about before, that information. Maybe some folks would want a full committee. So, and somebody,
That would be on Friday.
I think today's docket will be Friday afternoon.
Okay.
And it's gonna be a potentially long docket, and we have subcommittees afterwards.
We'll have state police come with their information.
Yeah, you're already be there for your other bill anyways. There may be some who want to mischaracterize the nature of this fee increase, so I'd be prepared to defend the cost of the system relative to the revenue being generated. Because the bad guys are paying. Or me when I get pulled up.
But you're a good boy, Mr.
Exactly. Okay, anybody have any questions for the patron? Anybody here speak in opposition to the bill? All right, the bill is before the subcommittee. All right, we have a motion to report and second. Assuming that this motion is adopted, we're going to keep this on the contested calendar so that they can come and present that information. All right, all those in favor say aye. Aye. Those opposed? I'm actually, and this is me just talking, this probably should have gone to criminal because it really has nothing to do with civil. I don't want to send it to criminal because that just causes you problems. But this is, I'm not.
Mr. Chairman, and you would no longer be a good boy.
And he would never send any one of our things to appropriations.
Maybe Delegate Cole 45 bill.
All right, so we'll have two of Chairman Lingerfelter's bills on the full committee contested docket to present that additional information. All right, before we hear the next bill, we've lost Chairman Kilgore had to go to a 3:30 meeting that he could not miss. He's planning to come back. Two of you are going to get pulled at the same time to criminal to deal with the suspension stuff. So we do need to make sure we can knock some of these out. Is yours just 1811?
That's it.
All right, let's knock yours out since you're going to get pulled away. All right, Chip, come on up. There's a substitute to HB 1811 that is in your stack. If everybody take a look at that while Manoli Delegate Posse walks the podium. We'll adopt that once everybody's had a chance to take a look. Are you over there too? Yeah. Okay. The only issue we have is making sure we keep a quorum. If you do leave, if you're a member of the committee and you leave to go across there, assume you need to come back as soon as you can. I hate to make people run back and forth, but we're going to lose a quorum and be stuck sitting over here. So, all right. 1811 substitute before you. Have a motion on the substitute? All right, move to second. All those in favor say aye. Those opposed? I think this is a bill that I hated at the beginning, but everybody worked out, right?
That's right. So in the interest of, not judicial, but committee economy, if Mr. Dix could just roll you.
Absolutely.
Thank you, Mr. Dix.
Mr. Dix on behalf of the Northern Virginia Apartment Association and Virginia Association of Realtors. The first change is on lines 44 to 45, and what that does is just incorporates the provisions from the Virginia Residential Landlord Tenant Act about the fact that in court, the judge would look at the rental agreement at least to determine what amounts are due and owing. The next change is on lines 64, and this is in the process, if you will. You recall that when you go to court on unlawful detainer, you have a right to request judgment of possession at the initial docket call, or you have a right to ask the judge to litigate the issue of possession and then defer the issue of rent damages for up to 120 days. All this does, I would represent to you, is to clarify that existing process because there's confusion among the bar and among some judges as to how that process works. And again, this has been worked out with all of the various different interested parties in that regard. The next change, Mr. Chairman, for the subcommittee is on line 87, 8101, 129, and this deals with orders of immediate possession in lines 94 through 102. And what that does is when you go to court now as a plaintiff landlord, you can ask if the tenant does not appear in court, or if there's an immediate mild rental, some kind of serious criminal situation, you can ask for the judge to enter an order of immediate possession. What that allows you to do is be able to walk out of the courtroom into the clerk's office and request the writ of eviction to be processed. It's processed, but the question is, can it be executed and can it be evicted before the tenant's 10-day appeal period runs out, or they otherwise appeal the case? So the language on 100 through 102 clarifies that in no sense, under the order of immediate possession, can an eviction occur prior to the expiration of the 10-day appeal period. The other thing,
And the bill was introduced, as I understand the old law is default and one of those things. The bill was introduced, said default or one of those things, made a 4-part list, and allowed for immediate. What you've done in the substitute is address that 10-day appeals window, so someone notices the appeal prevents the immediate execution.
that is correct.
Okay.
And what we've done, Mr. Chairman, and the last change, if you will, is on 111 and 112. And what it does is to deal with sort of the efficiency, if you will, of satisfaction of judgments. So all creditors are required to satisfy judgments within 90 days. And so what this does is goes in and just says, here's the court date, here's the case number and the name of the defendant and who we satisfied the judgment. So that the other information is not necessary for purposes of satisfaction of
To
the
make
judgment.
sure I understood what you said. They
Well,
don't have
I'll
to satisfy
explain to
the
you how it
judgment.
happens. I'll tell you what happens. You send in notice satisfaction and you get, so let's say you got a judgment for $575 for the rent and then late fees, court costs, attorney fees, you got this bulk, it adds up to $1,200 and 58 cents. Well, the tenant comes and, you're satisfied with them paying you $1,000 to call it a day. You send a notice of satisfaction into court, and if you don't get it down to the penny, they send all the paperwork back to you. So it makes you spend a lot of money and time and effort on stamps and waste time when it's unnecessary. The point is, when you send a notice of satisfaction into court, you tell them, hey, the thing has been satisfied, I'm satisfied, that should be the end of it. So creditors are going to be happier because it makes the process simpler. Debtors are going to be happy because they're getting their